Hello and welcome to the Disability Law Q&A. I am Martin Willemse. I'm a partner at the firm of Samfiru American and the Western Canada Disability Practice Leader. We've got our firm as offices in Ontario, BC, and Alberta, and we represent clients throughout Canada other than in Quebec and the territories. This session is dedicated to questions regarding long-term disability benefits, short-term disability benefits, and if you've got questions regarding critical illness or life insurance benefits, you can send those along as well. I'll respond to questions as they come through in the social media platforms, so please, I welcome any question related to those topics. We've got 30 minutes. They usually go by quite quick, so I'll get right into it. What do? We represent clients who have denied claims, be it disability claims, life insurance claims, or critical illness claims. And the way that we do that is we represent clients through the process of a legal claim. What is the role of a disability lawyer or a lawyer when you're represented when you've got a denied claim? The lawyer will maintain all communications with the insurance company. No communications will go through to you as a client any longer. All communications will be between counsel. You're also advised of your rights and obligations under the terms of the policy, which often people do not understand. You do not simply have rights, you also have obligations as to what you must do under the terms of the policy to protect your rights and to make sure that if you are receiving benefits, that you continue to receive those benefits. A lawyer will also advocate your position and as well build a strong case to maximize the compensation that you can receive. The vast majority of these cases, when I say vast, I mean over 99%, if not more, do not end up going to trial. So these cases, for the vast majority of them, result in settlements that are negotiated between counsel, your lawyer, and the counsel for the insurance company. When we speak about legal claims, there's a difference between doing an appeal, which is what you're doing at your end if you want to engage with the insurance company by yourself, not have a lawyer represent you and try to convince the same entity that denied your claim that they were wrong, that they should instate your claim. That's what an appeal is. A legal claim is entirely something different. There you take a back seat, you focus on your treatment, you focus on seeing the doctor regularly, and all communications, as I said, go through the lawyers and your lawyers specifically who represent you. If you've got questions about that, by all means, reach out to us further. So there's a bunch of questions coming in already. I've got a question on Facebook from Wayne. I was recently hospitalized with blood clots in my lung. Would I be entitled to disability benefits? It's a good question because I have this discussion every week with someone. A disability claim is focused on functional impairment. Diagnoses, in other words, what is your diagnosis? What is your illness? What is your injury? What is your condition? Of course, that is important. But the most important thing is functional impairment. What are your restrictions? What are your limitations that prevent you from working? If you've been diagnosed with blood clots on your lung and you've been hospitalized, sounds serious to me. The focus there would be, what are the results? What are the consequences? What are the restrictions, symptoms, and limitations that you have as a result of what has happened to you? How does that impact your ability to perform the duties of your own occupation? Often, and I've used this as an example many times, people would say to me, my doctor has diagnosed me with anxiety. We've submitted the documents to the insurance company. They've denied my claim, yet my doctor say I cannot work. I don't understand why. The reason why is there needs to be evidence as to the functional impairment. Lots of people have anxiety, yet they are able to work. They may take medications, they may have counseling, they may be in a position to perform the duties of their occupation with accommodations. So lots of people do work with certain conditions. The question is, when you submit a claim for disability benefits because you say you cannot work and your doctor agrees, why is that? What are the restrictions? What are the limitations? Going back to the example of somebody who has anxiety, it would be, let's say you work as a police officer. You have extreme anxiety because of issues that you faced in your job. Now you can no longer face the public. You have panic attacks. Your condition manifests itself in a physical way. You've got a fast beating heart. You've got palpitations. You cannot leave the house. You cannot sleep. You cannot focus. You cannot concentrate. Those are restrictions, those are limitations. When you look at those, then you compare it to what the person has to do as part of their occupation. And the question then becomes, how do those restrictions and limitations impact the person's ability to perform those duties specific to their occupation? When a doctor completes reports, that should be the focus. What are the symptoms? What are the restrictions? What are the limitations that would impact you from performing your duties? Now, that goes back to this question about the blood clots. Being hospitalized obviously means that it's quite a serious condition. But how does it impact your ability to perform your duties? With that being the angle and that being the focus, have a discussion with your doctor, whether the doctor supports that you cannot work, that the doctor understands what your duties are and what your restrictions and limitations are to the extent that they would impact your ability to perform those duties. And that question and that answer, rather, applies to all conditions. People often would ask it, I have a migraine disorder. Is that a disability? Or I have uncontrolled diabetes. Is that a disability? It all depends on whether the restrictions and limitations arising from that condition impact your ability to perform your duties. Okay. Question on YouTube from @Mirkoandelich6777. Are investigators allowed to install something on your car or phone to track you like GPS tracking devices? Can they see your text messages? There are privacy laws. What usually happens is an insurance company may retain an investigating company to do online surveillance so they can see what's happening on your social media platforms. They can do investigations whether there's been any litigation filed in your name or against you. They can see what properties you own, etc. When they do actual surveillance, they cannot tap your phone. They cannot hack your emails. They cannot hack your accounts. They're not allowed to do things like that. What they do is they may follow you around. So no, they cannot put taps on your vehicle. Cannot imagine that such a thing would be allowed, or would be legal rather. So what they do is they may follow you around. They may sit outside your house. If you leave your house, or if you appear outside of your house, they may record you on video. If you travel outside of your house, this happens a lot when people report that they cannot do certain things. If you receive a questionnaire, these logs, daily logs to be completed by insurance companies, say, what are your activity? Please complete activity logs for the next 2 weeks. That may very well be an indication that they will be doing surveillance, because they're going to be looking at what did you complete on those activity logs and compare it to surveillance that may have been doing over the same period. In other words, if you say, I have a bad back, there are certain things that I cannot do. I cannot lift, I cannot stand for extended periods of time, I can sit for very limited periods of time. I don't do any household chores, mainly I have to lie down. I may be able to do a little bit, but not much. Then they do surveillance of you. And if you did not accurately complete those activity logs, then they will report to you that they believe that there is a credibility issue, not that they would necessarily use that language. They may say to you that the perceived ability seems to be greater than what you were reporting to them. So surveillance is a very helpful tool to insurance companies. When you report your restrictions and limitations, be clear as to what those are. Don't exaggerate, don't underplay. Of course, some days people have better days than other days, but you cannot always have the better days when they do surveillance. So be accurate when you report your restrictions and limitations. It often happens as well that a person does have a good day. They may do something beyond their ability that they usually are able to do, and then they pay for it for the next few days. So I've represented many clients where there is surveillance, where the surveillance was conducted for 5 days. The first day, the person is quite active, and then for the second and third day, they don't even leave the house, which supports that, yes, people do push themselves, but then they pay for it, which means that they cannot consistently be employed. So can they see your text messages? No, they cannot. Let me just see. I think this is a question that came in 2 parts. At BallerL-the future 956, Have you had cases where a case manager called a police wellness check on an LTD client? Can I take them to court? I'm still getting LTD. It is very traumatic. No, I haven't had an instance like that happen before. I have had instances where a person was reporting issues, not issues, that they were reporting to the insurance company that they were really struggling with their mental health, that there were suicidal tendencies, and that the insurance company reached out to the doctor or to the counselor or provided them with a helpline because there was a concern as to what would happen. But I haven't had an instance where a police wellness check was ordered. I understand that that is quite traumatic, and it would be very traumatic. If you've got further questions on that, you're welcome to contact us. If you're still receiving LTD, I suppose that part is a good thing. You may want to have a discussion with your doctor about what had happened and how that has affected you, and document everything in writing so that your doctor, if there were to be a denial later on and if there were to be a legal claim, that everything is well documented, as well as how this impacted your mental health. I understand that it was very traumatic. You would have reported that to the doctors. If the doctor had concerns about it, they would report it as well, so that there is a written record of the events and how it negatively affected you should this proceed further. At Haley, HAO.ZAK, I did an FCE. I think this is on YouTube as well. I have eye pain that prevents me from using computer for too long. I push myself a bit too hard in the FCE and have subsequent flare-up. How do I make sure assessment consider that? At what point do they... Okay, sorry. I think there are two different questions here. So if you had... This often happens when somebody does an FCE and they have a flare-up. I would make sure, if I were you, to see the doctor immediately. Report to the doctor how the functional capacity evaluation, for those who do not know what an FCE is, how that impacted your ability or your condition. If there was a flare-up, then you want to make sure that the doctor documents it. Similar to my previous response, you want to make sure that there is a written track record of anything that the insurance company was maybe involved in that led to a deterioration or an exacerbation of your condition. Also, if you are still in contact with the FCE assessor, you may want to contact them and say, I had a flare-up and this is what happened, so that it forms part of the opinion or the factual assumptions before an opinion is rendered. But make sure that you report to your doctor how this impacted you, and continue to see your doctor regularly. In any event, in any claim, you have to see your doctor on a very regular basis and make sure that you accurately report to your doctor your ongoing restrictions and limitations. If I had $1 for every time I said restrictions and limitations, I would be a rich man. Restrictions and limitations, remember that. That is what is key for any disability claim. How do you record that? You make sure that when you see your doctor on a regular basis, which is another duty that a person has when they are receiving LTD benefits, you want to make sure that when you receive your doctor on a regular basis, that what you report as a worsening of your condition or any new symptoms, that is recorded by the doctor. Make sure that your doctor writes it down or types it into your chart, because the insurance company at some point is going to get a copy of those charts from all the doctors who you see. And if there's no report in those charts of what you report as to be your restrictions and limitations, it's going to make it easier for them to maybe discount what you're saying to them. So make sure that your doctors record it. Haley also asked, at what point do they do surveillance? I am at 24 months mark being assessed for change of definition. Would they do this now? It is possible. It depends on who you are dealing with, which case manager. I cannot sit here and say to you that everybody who has the change of definition approaching will be subject to surveillance, because that would not be true. But what does happen is, often with a subjective condition, or when there may be an issue with credibility as it is perceived by the insurance company, or if there is no improvement and the person's reports remain that the condition is quite severe despite various interventions, and there would be a possible expectation that things should improve, they may then do surveillance. So it really is a fact-by-fact analysis. But at the 24-month mark, yes, it is possible that it could be done. Will it be done? I don't know. But do know that if they reach out to you and they want you to complete these activity logs, that is very likely an indicator that surveillance is going to follow. Question on Facebook from Monique. My employer says my benefits end if my employment is terminated. Does losing my job mean I automatically lose my LTD? That should not be the case. LTD is paid to you if it is approved pursuant to the policy that you have with the insurance company. That policy is a contract. The contract requires that you prove ongoing disability. You had, and you're receiving benefits now because when you went off work, the policy was in place. So your claim vested then. Whether your employment ends or not should not be a factor as to your ongoing entitlement to benefits. Your ongoing entitlement to benefits depends on ongoing submission of proof that you remain disabled within the meaning of the policy. If for whatever reason your disability benefit ends or is terminated by the insurance company because they say your employment terminated, please reach out to us because that would not make any sense to me. We offer free consultations throughout Canada, other than in Quebec and the territories, where we will assess your claim, look at the denial letter, look at the policy if you've got available, look at medical evidence, and discuss with you your specific circumstances so that at the end of that consultation, you have information to make an informed decision as to how you want to proceed. Okay. Paula asks, can I sue that insurance company for the police wellness check? It is possible in certain instances where, let me backtrack. An insurance company has a duty of good faith. So that's the cornerstone of a disability policy. These are peace of mind contracts, meaning that the insurance company has to act in good faith, meaning that they have to treat you reasonably and look at evidence objectively. Even while on claim, can you pursue a legal claim because of the conduct of an insurance company? It is possible. It doesn't happen often, but it really depends on the factual circumstances. So in theory, I would say, yes, I think you can do that. Whether it is a claim that is viable, it depends on the specific circumstances. I cannot give you legal advice on that at this point, but in theory, can you sue because of something like that and it caused further harm? Yes, you should be able to do so. At Catherine Leeds, also on YouTube, asks, my sister is on disability leave. Her doctor has been suggesting she starts to try and go to the gym to help with her condition. She's worried about her insurer using this as a reason to cut her off. How can she approach doing this and head off the insurer at the pass if they raise a stink? This is a good question because sometimes you're damned if you do and you're damned if you don't. Remember when I said that people also have obligations under the terms of the policy and in common law? One of those things would be that you have to mitigate, meaning a person who is on claim has a duty to mitigate their losses. That means that you have to take reasonable steps to get better. Reasonable steps. In other words, reasonable steps to follow through with proper treatment so that you can improve, so that you can get back to work. Another thing that is under the terms of the policy, and many of them actually detail this, is you must receive appropriate treatment for your condition, which also means, which I often see in cases where we represent clients, that insurance companies may raise a defense saying that your client is not mitigating, or they're not receiving appropriate treatment for their condition, or they are not following through with recommended treatment advice. So where do we start? Your sister is receiving disability benefits. She has a doctor, as far as I understand, suggesting that she starts to try and go to the gym to help with her condition. So number one, you have a doctor who is recommending treatment. The treatment is to start to go to the gym. If she does that, number one, she's receiving appropriate care for her condition and she's following through with recommended treatment. So she's abiding by her obligations under the policy. If the doctor is recommending that, again, this seems to be the theme of this discussion this morning, make sure that the doctor puts it in writing, and she can, if this is raised by the insurance company, provide it to them. Say, look, my doctor has, even if it isn't in writing, she can still say to the insurance company, if it is raised, that her doctor. Sorry, I just lost the connection there. A doctor can prove that, or provide evidence that she is required to do this. So she's following through with recommended treatment advice. But do what the doctor says. Do it on a light basis, do it on a gradual basis, because the insurance company will be looking at, is there evidence to support that there is a possible denial that may follow. I hope that was helpful. If your sister has further questions on this, by all means, reach out to us. At Anna Seats says, how long does an employer have to hold a position for you if you are off on long-term disability? So that is an employment question. We do have an employment Q&A coming up tomorrow. By all means, do ask that question tomorrow. I believe there it is on the screen. It would be at 1 p.m. Eastern Standard Time, which is 10 a.m. Pacific Standard Time. And that's with my partner, Leor Samfiru. Question on YouTube from Yvonne. My benefits state short-term disability is paid at 60%, but the employer placed a cap of how much you can be paid, which amounts to only about 40% of your weekly base pay. Can they do this? Can they tell employers that the STD is paid at 60% and only pay them at 40%? That doesn't sound correct to me. What I would think should happen there is reach out to a disability lawyer. You can reach out to our firm. We can actually look at the policy, because how this should work is there should be a policy in place. The vast majority of cases or disability claims are based on a policy, right? A contract. That policy that you have is a contract. Short-term disability benefits may be a little bit different, because we're not sure if it is paid pursuant to the terms of a policy, or if it is a self-insured plan that the employer has to pay short-term benefits. That often is the case. So I'll speak a little bit more about that to just explain this clearly. With an employer, you have, for the most part, benefits. Now, everybody's is different. It depends on what you have negotiated or what your employer benefit package is. Some people may have short-term disability benefits as a benefit with the employer. Of those people, some of those short-term disability benefits may be paid pursuant to a disability policy that your employer has negotiated with an insurer, which means that the insurance company pays the short-term benefit. In many other instances, you may have weekly indemnity benefits or short-term disability benefits, but it actually is not paid pursuant to a policy with the insurance company. It is a self-insured plan that the employer has. So they decide how much is paid, but it should be detailed in a plan. The insurance company may be making decisions. In other words, their role is limited to gathering medical evidence and assessing whether the person is disabled within the meaning of the plan that your employer has. But when the claim is approved, it is paid by the employer. The insurance company has no financial liability to pay that benefit. Where with LTD, the vast majority of them would be insured by an insurance company, assessed by an insurance company, and paid by the insurance company. Short-term, though, is different. So on that question, that may be the issue. It depends on what the employer has and why they are working it out in the way that they do. But again, you're welcome to contact us if you have the supporting documents. We can review it with you. Okay. Question on YouTube from Carla. I'm on disability, but the insurance company is pressuring me to return to work, even though my doctor says I'm not ready. Who gets the final say? This is a tough one. The insurance company ultimately makes the decision as to whether they're going to approve the claim or not. Is their decision correct, though? If they're going against what your doctor says, I would argue that they are making the wrong decision, and you can take action, either through an appeal, which is you asking them to revisit their decision that they already made, or through a legal claim. Now, a few things more to be said. You are receiving LTD benefits. your doctor says you are not ready to engage in a gradual return to work, they are pressuring you. As with everything, again, I'm going to say this. Make sure that you see your doctor regularly. Your doctor is obviously advising that you not return to work at this time. Let your doctor put it in writing. Let your doctor explain why your condition is such that a gradual return to work at this time is not advisable. Why would that not be a good idea? Why are you not yet ready? What are your ongoing restrictions and limitations? And as well, let the doctor detail what your continued treatment would be. Your doctor does not need to say when you will be in a position to do gradual return to work, because it all will depend on the treatment and your recovery and your improvement. But what the doctor also wants to say is, if you are not ready to return to work, what would be the consequence if you were pushed to return to work on a premature basis? And the consequence very likely will be that such a gradual return to work is doomed to fail, may exacerbate or worsen your condition, you may have new symptoms, and that in itself may prolong recovery, which will likely result in a much longer time off of work, which will be the consequence of them pushing you to return to work early, and they will be left with having to pay you for an extended duration of time with respect to LTD benefits. That's what I would recommend. Now, whether if they denied you, the argument would be that they are breaching their obligations under the policy because you had a doctor supporting that you cannot work or return to work. But the clear message here as to all these questions, see your doctor regularly so that if this becomes an issue later on, your doctor will feel empowered and will be empowered by having seen you on a regular basis to provide an informed opinion. I hope that was helpful. Well, lots of questions. One more left. And we've got a few minutes. Oh, Haley. Haley asks, if after transferable skills assessment and FCE, the insurance company cut me off, but I can't find a job in the list of jobs they say I can do that pay 65% of what I made, what should I do at that point? Remember, Haley, if the insurance company denies your claim, it doesn't mean that they are right? If you and your doctor agree that you are not able to return to another job, just because they've detailed a transfer. I've had lots of cases where transferable skills analysis were done, but the restrictions and limitations that were communicated to the person doing the transferable skills analysis were not accurate, so that the foundation of the opinion was already flawed. Then the transferable skills analysis by itself has no value. If the FCE worsened your condition, which you said it did, I don't understand how you would be in a position to return to work to another occupation. Clearly, you're not correct yet, right? You're not ready to return at that point. So what one would want to do is, if there is a transferable skills analysis that is done and there's an FCE and they deny on the basis saying that they believe you can go work in another occupation, have a discussion with your doctor and please reach out to us because we can discuss with you what your options are. Do not feel forced that you have to now go find one of those jobs which they've detailed. If your position is that you cannot do one of those jobs or return to another occupation, you've got your doctor's support, you have a claim to pursue against the insurance company. Don't simply accept that their position is correct, because it often isn't. Reach out to us and we can discuss with you what your options are specifically so you can make an informed opinion. And again, those consultations are given on a free basis. So with all of that being said, and there's a lot that came in this morning or today, thank you so much. You can go to disabilityrights.ca for more information. My name is Martin Willemse. Tomorrow there's another employment Q&A at 10 a.m. Pacific Standard Time, 1 p.m. Eastern Standard Time with my partner Leo Samfiru. And to Rich Bygrave, I am from Pretoria. Thanks for asking the question, and I hope everybody has a great day. Thank you. Until the next time.